When we're looking at grants and patents, we must always look at them in the context of when they were written. And I'm referring here now to Joseph Chitty, who wrote a lot about grants and patents in actually 1820. So we have to keep that era in mind to try to understand the intent of what the grant and what the patent was doing for the first settler. So I'm just going to review a couple excerpts here, starting with the first paragraph. Because in general words the king's grant never extend to a grant of things which belong to the king by virtue of his prerogative, for such ought to be expressly mentioned. In other words, if under the general name a grant comprehends things of a royal and of a base nature, the base shall only pass. It is indeed expressly provided by the statute that when our Lord the King giveth and granteth to any a manor or land with appurtenances, unless he makes express mention in his deed in writing of king's fees, advowsons, merches, and dowers, when they happen, belonging to such manor or land, then at this day the king reserveth to himself such fees, advowsons, dowers, abet that among other persons it hath been observed otherwise. Grants. In the third place, the king's grants are upon a valuable consideration. They shall be construed strictly for the patentee for the honor of the king. How grants to and let me try that again. How grants from and to the king are effected, it is a clear rule that as well as for the protection of the king as the security of the subject, on the account of the high consideration entertained by the law towards his majesty, no freehold interest, franchise, liberty can be transferred from the crown but by a matter of record. So letters patent are a matter of record. This is effected by letters patent under the Great Seal, which is a record and evidence per se without further proof. So you cannot argue a matter of record. The crown is bound. And by the Nullum Tempus Act, in the 9th year of reign, George III, chapter 16, the king shall not sue, etc., any person, etc., for the lands, except liberties and franchises, or any title which has not first occurred within 60 years before the commencement of such suit, unless he has been answered the rents with that time, or they have been in charge, or stood in super of record, and the subject shall quietly enjoy against the king, and all claiming under him by patent. So it's telling you here that the patent is a contract, and once 60 years has lapsed, the king has no right to whatever has been given, granted, patented. Letters patent, being under the Great Seal, are matters of record, and therefore read without proof, and by the statutes, well, I'll skip that part, patentees and all claiming under them may make title by showing the exemplification or constant of the roll. Well, we're right back to the Evidence Act here, RSO 2006. That's the current interpretation. And these statutes have been held to extend to all of the king's patents which concern lands, privilege, or other thing granted to the subject, corporation, or any other. Now, some people will come back and say, well, what is a patent? Well, a patent is a private act. And this is from the Canadian website, and it says Table of Private Acts 1867 to 2021, and it shows patents. So let's just see where this falls in BNA. Section 129, continuance of existing laws, courts, officers, etc. Except as otherwise provided by this Act, all laws in force in Canada, Nova Scotia, or New Brunswick at the Union, and all courts of civil and criminal jurisdiction, and all legal commissions, powers, and authorities, and all officers, judicial, administrative, and ministerial, existing therein at the Union shall continue in Ontario, Quebec, Nova Scotia, and New Brunswick, respectively, as if the Union had not been made, subject, nevertheless, down in parenthesis, except with respect to such that are enacted or exist under acts of the Parliament of Great Britain or the Parliament of the United Kingdom of Great Britain and Ireland. So that means those laws, like our patents, which were enacted under the legislature of Great Britain, are, except from this, following to be repealed, abolished, or altered by the Parliament of Canada or by the legislature of the respective province, according to the authority of the Parliament of that legislature under this Act. So, if they're current acts of the province can amend them. But if they're of imperial nature, of the Parliament of Great Britain, the United Kingdom, Parliament or the legislature cannot amend them. And our letters patent were issued through the administration of the Imperial Government of Great Britain.